Good morning, everyone. A very warm welcome to all learned advocates, legal professionals, law students, and distinguished participants for joining us today. On behalf of Law Learning Bench, I am delighted to welcome you all to this important and extremely relevant session on the theme Bail is the Rule, Jail is the Exception, Effective Bail Advocacy for Advocates. Personal liberty lies at the heart of our Constitution. Yet, in everyday court practice, we often witness a stark gap between principles and practice. This session is therefore not merely an academic discussion, but it is designed to provide practical insights into how bail advocacy should be approached in real courtrooms, how arguments must be structured, and how counsels can effectively assist the court in safeguarding the liberty before magistrates, sessions court, and constitutional court. Before we move forward, let me briefly introduce the platform behind today's initiative, Law Learning Bench, a legal education initiative committed to bridge the gap between classroom learning and courtroom reality. The platform focuses on skill-based learning, advocacy training, and practice oriented legal education to strengthen the real world litigation and capabilities. Before we begin with the session, participants are requested to follow the rules as follow. Please turn on video camera to make sure that the session is engaging and effective for all. Kindly maintain professional decorum throughout. You're welcome to post questions in the chat box at any time. Our speaker will try to answer questions live wherever possible. All questions will definitely be answered either during the talk or in the Q&A segment at the end. Please avoid any interruption while the speaker is speaking. Before we begin, an important note, the session may be recorded for academic enrichment. All shared content is confidential and protected under the intellectual property laws. Kindly refrain from reproducing or sharing the material without permission. This now also brings me to the vision behind today's session. Advocate Mithilesh Kumar Pandey, founder of Law Learning Bench. Like many young lawyers, he too began his journey in crowded court corridors, full of ambition, passion, and determination to make a meaningful difference. Through years of rigorous practice, courtroom experience, and commitment to transparency and accountability in institutions, he realized that true advocacy is built not just on law, but on preparation, strategy, and purpose. With that vision, he founded Law Learning Bench to ensure that young advocates receive the kind of mentorship, guidance, and practical training he wished he once had. We extend our heartfelt gratitude to him for conceptualizing and organizing today's webinar. Moving forward, it is now my privilege to introduce our esteemed guest speaker for today's webinar, Ms. Mahalakshmi Pavani, ma'am, Senior Advocate, Supreme Court of India. Ms. Pavani holds the distinguished honor of being the first woman from Karnataka and the sixth woman in India to be designated as the Senior Advocate by the Supreme Court of India. This honor was conferred when the full Court of Supreme Court of India granted her the prestigious Senior Advocate's gown on 23rd April 2015. Throughout her distinguished legal career, Ms. Pavni has represented a wide array of eminent clients, including the Union of India, the state of Punjab, and several prominent and constitutional figures such as Sonia Gandhi, Rahul Gandhi, H.D. Kumar Swamy, late Dorji Kandu, and late J. Jayalalitha, as well as ministers from different states across the country. With an extensive courtroom experience and deep constitutional insight, Ms. Pavni is exceptionally well placed to guide us on how the principle of bail is the rule, jail is the exception, must be effectively argued and applied in real courtrooms. With this introduction, I now invite ma'am to take the session forward and share her insights on effective bail advocacy. Ma'am, the virtual platform is yours.
Thank you, Shreya. Thank you very much. Thank you, Law Learning Bench, for giving me this opportunity to address students. I'm not an expert, but it will be my endeavor to highlight what bail is about, what are the provisions of bail, what kinds of bail are there, and the important case laws on what the bail controversy revolves. And I also thank Mr. Mithilesh Kumar Pandey for giving me this opportunity to address students. And students, I'm not a very good teacher, so please bear with me when I start. And if you have any questions, it will be my endeavor to answer that to the best of my knowledge. So here we go. So this we will be discussing what bail really means and how it applies in the context of the Indian legal system. So what do we say when we say bail? We say bail is a means by which a suspect is released from the custody of the state for a temporary period. It is a fundamental component of the criminal justice delivery system. So the right of bail actually is rests on the ground norm that of criminal justice, that is presumption of innocence unless proven guilty. So we have the origin of the bail from can be traced to clause 39 of Magna Carta, which reads as, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by lawful judgment of his equals or by the law of the land. And this I found it in the judgment of Nikesh Chandra Shah, the celebrated judgment by Justice Rohinton Nariman when he was dealing with bail under PMLA. So what is actually bail? Bail is an assertion of freedom against the state imposing restraints. So it is a mechanism whereby the presence of the accused is assured. It is an universally accepted principle which beyond the pages of our constitution finds acceptance in international covenants and instruments like the ICCPR, that is the International Covenant on Civil Political Rights of 1966, which contain that time-bound trials should happen, because justice hurried is justice buried also. So, and we have to focus on what are the fundamental rights, whether justice is being given, whether it's going to be meted out, what is the time limit, whether it is his fundamental right to life, Article 21, whether he should be, and on what conditions he will be released, when he has to appear in the trial. So these are the things, and they are situated they are got even from the Universal Declaration of Human Rights. Bail is not defined anywhere. It is not defined in the Criminal Procedure Code or any other legislation, but CRPC or BNSS, it talks of offenses which are labeled as bailable and non-bailable. So what is the difference between bailable and non-bailable? If the punishment is less than 3 years, then the offense is bailable. And if it is more than 3 years, it is non-bailable. The Supreme Court in the year 2009, in the case Vaman Narayan Gia versus State of Rajasthan, they tried to define bail, and they defined bail, and they actually took the term, determined the origins from the bailer. Bailer is bailer means to give or to deliver. Bailer and bailier means to bear a burden. And Stroud's Judicial Dictionary explains bail. I'm reading it out to you. When a man is taken or arrested for felony, suspicion of felony, indicted of felony, or any such, so that he is restrained of his felony, and being by law bailable, offers surety to those which have authorities. Sureties are bound for him to the king's use in a certain sum of money or body for body, that he shall appear before the justices of gold delivery at the next session. Upon the bonds of these sureties, as is aforesaid, he is bailed, that is to say, set at liberty until the day appointed for his appearance. And Black's Law Dictionary defines bail as the procurement of release of a person from legal custody by undertaking that he shall appear at the time and place designated and submit himself to the jurisdiction and judgment of the court. So the BNSS, that's the new Criminal Procedure Code, speaks of bail, defines bail as under section 2(1)(b) as release of a person accused or suspected of commission of an offense from the custody of law upon certain conditions imposed by the officer or court, or by on execution by such a person of a bond or a bail bond. The main idea behind granting bail is to respect a person's right to his liberty, personal liberty, under Article 21 of the Constitution. It is not a privilege, it's a right, unless, of course, there is a valid reason to deny that liberty to him. So the fundamental principle the fundamental principle remains that the personal liberty is a constitutional right under 21, and it guarantees the right to life. But the new laws also continue to assert that pre-trial detention is an exception and should not be used unless absolutely necessary. Bail is actually a right, an assertion of freedom against the state imposing restraints. And it is a balancing act between the personal liberty of an individual and security of a state. And it ensures that even if a man is given bail, he comes to the trial, he appears before the concerned judge, and he subjects himself to the jurisdiction of that court. And to secure his presence, a surety is taken and conditions are put. So when a bail is granted, the judge will say, we give him on a surety of 10,000 rupees. He will produce a bail bond. He will surrender his passport. He will, these are the conditions. And sometimes if they are very small crimes, like they say, they give community service. They say you will attend the orphanage and clean up, or you will visit the prison and give legal advice if he's a law student and he's committed of some small crime or something like that. So there are various conditions. You remember the Pune case where the man had the car accident, where the judge imposed a very frivolous condition of saying to write an essay. That was a perverse order that should not have been done. Unfortunately, it has been done because that man, the accused, was a very influential character. So because he was a minor, they imposed such conditions. Such conditions are normally not levied or imposed. So that was a wrong thing. And this surety also, normally in Moti Ram's case, that was in 1978, Justice V.R. Krishna Iyer ensured that one could get bail on one's own security without, on one's own bond, without any other person giving security or surety for them. So, and this term, bail is jail, and bail is not jail. Bail is the rule and jail is the exception, was also coined by Justice Krishna Iyer in his very famous judgment of Guddikanti Narsimhalu versus Public Prosecutor, High Court of AP. There he held, I will read what he held. He held that bail or jail at the pre-trial or post-conviction stage belongs to the blurred area of criminal justice system and largely hinges on the hunch of the bench, otherwise called judicial discretion. Basically, bail means it is the judicial discretion. It is upon the judge himself whether to grant bail or whether not to grant. But unfortunately, in today's scenario, the social media is so widespread. So there is a parallel trial going on called the media trial. And judges are also human beings and they are sometimes influenced. So their influence, the power of social media is so great that it tends to overpower the vision of the judge. Sometimes the judge, even if he finds no good ground to give him, he finds all good grounds to give him bail, but because of media pressure, he does not give bail. So, it is a cutting a knife with two cuts, both sides you can cut, whether you can cut for good or for the bad. So it has a cutting edge. So media trial is something which judges should, insulate themselves from media, and depending on the facts and circumstances of the case, and whether he's at flight risk, whether he has the ability to tamper with evidence, whether he can influence witnesses. These are the things that have to be considered while granting bail. So the most shocking part of this bail was in just 2-3 days ago, the Delhi High Court suspended the sentence of a POCSO accused, a gang rape man, a man who had gang raped, who had killed, he was a very, very prominent figure in the UP government. He was a BJP legislator 5 times. He's been expelled. But unfortunately, when his appeal was pending before the High Court, they said, okay, fine, we have to think about his liberty and all. And they put this condition that he cannot come within the 5 kilometers of the accused, of the victim. It is very sad. The victim, she has been crying hoarse. She wants justice, but here the court has found that he's not a public servant under the POCSO Act, and saying that he's not a threat. Unfortunately, the court lost sight of the fact that here was a man, and when this case was happening, the father died in judicial custody. Father was actually arrested under the Arms Act. That was another, it was a pre-planted thing. It was a conspiracy to put the father behind the bars so that the child, the victim, the minor victim, withdraws her complaint. So they tried to pressurize. The man died in judicial custody. The uncle and the 2 aunts were traveling to give evidence, and the car met with an accident. They were killed. The girl and the lawyer escaped unhurt, with minor injuries. Despite knowing all this, the High Court unfortunately suspended the sentence and said that he should be released within 1 hour. So what I'm trying to say is, the court should not lose sight of the fact here of who is the victim and who is the accused. And justice should not only be done, it should seem to be done. By giving this, the message is very loud and clear, and it's a very sad message that people will lose faith in the judgment, in the courts altogether. So this should not be it. They should treat everyone as convicts. Here he is not even an accused. Here he was a convict. The trial court had already convicted him of life imprisonment till death and imposed a fine. So here it was not as if his charge sheet was not filed or as if trial had not happened. Everything had happened. Just a minute. So, see, this was one example where the court should not have granted bail or suspension of sentence, but still they went on to give. And now she has approached the Supreme Court. So Supreme Court, and this was a case where Supreme Court had suo motu taken cognizance and transferred the entire cases out of UP, Unnao, to Delhi. Why? Because that man was a political bigwig, and he had the wherewithal to tamper with evidence, to influence witnesses, and her father, uncle, aunts were all killed. So here you could see the power of a man. He did not have to be within 5 kilometers. Even sitting outside, he exercised so much of power. So then there are other notable cases like Husainara Khatun versus State of Bihar, where Supreme Court addressed the issue of under trial prisoners and expedited their release, and who had been detained for many, many years. Then you have this economic offense case of 2011, the CBI Sanjay Chandra's case, where it also that economic offenses also warrant bail, highlighting the provision, deprivation of liberty cannot be justified because a person is accused of a serious crime. Then what has, Then you had this Arnesh Kumar, which was very big judgment, and it came as a great relief to all those who were facing trial under Section 498 of CRP, IPC. So that was actually dealing with, you see, 498 was against dowry and women and harassed women. It was kind of a protection. But soon what women did was they started using this as a tool for taking out revenge or vengeance, or to blackmail or arm twist the husband and their family. So they would go and file an FIR under 498 and say, my father-in-law, my mother-in-law, my sister, a sister-in-law, my grandmother-in-law, even sister-in-law who was sitting in the US, they would, drag her into these kind of criminal proceedings. So they had to be arrested. So what Arnesh Kumar, when they dealt with it, they said that they put an embargo on this arrest. So they said that first and foremost, you have to assess the necessity of the pre-trial detention and ensuring that arrests and detentions are not arbitrary. So what happened was, here the court told the police officer, in the pith and core of this entire Arnesh is when it lays down some guidelines. It said the police officer first should, he, before arresting a person, he must put a question to himself and say, why arrest? Is it really required? It is, and what purpose it will serve? What is the object which will be achieved? And it is only after these questions are addressed, the power needs to be exercised. So he must be satisfied that the arrest is necessary. So when this power was given to police officers, the number of arrests came down under Section 498A, and there were many cases that were weeded out. So this was actually a breather for so many victims, false victims, where they have been accused falsely by the women. So this was a nice landmark judgment by Justice C.K. Prasad. Then what are the types of bail? So we have the anticipatory bail, then we have interim bail, we have regular bail, we have default bail, we have transit bail. So these are the 5-6 types of bail. So what is anticipatory bail? So anticipatory bail is a pre-arrest legal remedy which is available to a person who apprehends arrest on accusation of having committed a non-bailable offense, and it involves the discretion of the court to grant bail by the court or the High Court. So if the anticipatory bail is not granted by the Sessions Court, they can move to the High Court. And that means if he has an idea that he is going to be arrested, then he can move for this. So when a man applies for anticipatory bail, one should remember to keep the facts very minimal, because we don't give all the facts on a bail application for anticipatory bail. You have to be very minimal. You just have to say that I am not a flight risk. If you want, I will surrender my passport. I will cooperate with the investigation. I am being falsely implicated. This case is a counterblast to something that has happened. So I apprehend that I will be arrested and I am seeking protection, period. And that is for a short period. So if they are arrested, they will be granted bail. And if he has been granted anticipatory bail, the police cannot take that person into custody. Actually, this anticipatory bail provision was a concept which was introduced in 1973. In the earlier CRPC of 1898, it did not have any such provision or section. So it was only recommended after the 41st and the 48th Law Commission reports. So that is the time when this anticipatory bail came into the CRPC. So, and it has no definition as such. It's not defined anywhere. But the general meaning is that if he is likely to be arrested, he should be released on bail. And that was definition came in Balchand Jain versus State of MP in 1976. Then you have this Constitution Bench judgment of Gurbaksh Singh versus Sibia versus State of Punjab. So they had an occasion to deal with the scope and ambit of anticipatory bail. So Justice Chandrachud, Chandrachud, Yashwant Chandrachud, held that provision in CRPC is an extraordinary provision where the accused who apprehends arrest on accusation of having committed a non-bailable offense can be granted bail. So I will read what he has held. He says, a wise exercise of judicial power inevitably takes care of the evil consequences which are likely to flow out of its temperate use. Every kind of judicial discretion, whatever may be the nature of the matter in regard to which it is regarded to be exercised, has to be used with due care and caution. In fact, an awareness of the context in which discretion is required to be exercised and of the reasonably foreseeable consequences of its use is the hallmark of a prudent exercise of judicial discretion. One ought not to make a bugbear of the power of grant of anticipatory bail. So, and one of the most vexed questions in the anticipatory bail is the duration of the anticipatory bail. And when can the court be moved for anticipatory bail? When does it last? And does it last to the end of the trial? So these questions were examined in a case titled Sushila Aggarwal versus State of Delhi, NCT. And it held that no time limit is necessary for granting anticipatory bail. And I will be reading what it held actually, Sushila Aggarwal. So it says, despite several law commission reports and recommendations of several committees and commissions, arbitrary and groundless arrests continue as a pervasive phenomenon. Parliament has not thought it appropriate to curtail the power of discretion of the courts in granting pre-arrest or anticipatory bail, especially regarding the duration or till charge sheet is filed or in serious crimes. Therefore, it would not be in the larger interests of society if the court, by judicial interpretation, limits the exercise of that power. The danger of such an exercise would be that infractions, little by little, advisedly kept wide, would shrink to very narrow and unrecognizably tiny portion, thus frustrating the objective behind the provision which has stood the test of time, that is 36 years. This is what Sushila Aggarwal said. So they have not actually prescribed. They have not categorically said till how long will this anticipatory bail be there, till it be end of the trial or nothing. So it was basically in the air kind. So, and then after that, they came to interim bail. What is an interim bail? Interim bail is a temporary bail granted to the accused while the final decision on the regular application is pending. And anticipatory bail will be valid during this time, ensuring that the accused is not detained by any law enforcement without just cause. So it is only given for a short duration, and then the applicant must apply for regular bail within this time. So interim bail could be a medical bail where he has to undergo certain dialysis or a heart procedure or something. So that is the time when they grant under medical conditions. And what is a regular bail? Regular bail is actually granted to a person who has been arrested or is in police custody during an ongoing investigation or trial. And there is some disturbance in between.
Are requested to mute their microphones.
Yeah. So, so regular bail, bail is given on certain conditions. As I told you earlier, they will ask for a surety, they will ask for a bail bond, they will say that you will not go out of the country or not out of the state, you will report to the police station every week at this time, you will sign the register. So these are the conditions that are given in a case of a regular bail. Then there is called a police bail. What is police bail? It is a release of an accused person by the police themselves, and the person does not have to appear before the magistrate. So the police, if they decide to grant bail, they will grant bail, and it is typically for minor offences where the law makes it mandatory for the police officer to release the person. And in specific situations where the police decide not to detain a person further while the investigation is still ongoing, they can grant bail. It is their prerogative. Then you have something called a default bail. So the right to be released if investigations are not completed within a prescribed time. So section 57, it said if a person is arrested without a warrant, he cannot be detained for more than 24 hours. So then there is Article 22(2) of the Constitution, and it mandates that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. And such arrest is including the time necessary for travel and things like that. So that is a kind of default bail. And there are two types of default bail is an indefeasible right of an accused. So when the charge sheet for a bailable offense, it's 60 days and non-bailable 90 days. If it is not done in that time, the court can definitely grant bail to that person. So that is called default bail. And he should, the person, if the charge sheet is not given, or if within 60 days, the man is entitled for bail, and he cannot be kept beyond 60 days in a prison or as an under trial. So that is kind of default bail. Then you have something called transit bail. What is transit bail? It is a temporary court granted protection from arrest. You are living in Delhi and there is a case, FIR registered in Bombay. So you have to appear there. You don't know anyone there and you're new to the place and you've not been there, but simply you've been implicated. So you go to the Delhi court and you ask for a sessions court, you go and ask for a transit bail. And you say, please prevent me from being arrested till I am taken into custody. Let me, in the interim, from me traveling from Delhi to Bombay, I need protection. So, and when you go to Bombay, then you apply for a regular anticipatory bail. So it is actually preventing arrest during the journey. So that is a transit bail. Sorry. So this right to bail again is an area of conflict between the police's power to restrict liberty of a man alleged to have committed an offense and the presumption of innocence in favor of the accused. So bail is, as I said, why is it granted? It is granted to secure the presence of an accused during trial or investigation. It can be refused for a number of reasons. Bail is the discretion of the court. It is the judicial discretion. It depends on the judge who wants to grant him bail. So, you know, I told you sometimes judges are under pressure, media trial and things like that. So they tend to be more strict, or sometimes they are more liberal. So it all depends. But the in a bail application, what do you say? You say you're a citizen of India. This is, I am so many years old. My health is not good. I'm suffering from such and such a thing. So many diseases. I have children. I am a family man. I work here. I'm a law-abiding citizen. I will cooperate with the investigation. I am not at flight risk. I will not tamper the evidence. And if there are witnesses, not independent witnesses, if the witnesses are all of government officers and things, they can grant bail because he will not be able to tamper with any witness, any evidence as such. So these are things there, and it is actually the subjective satisfaction of the judicial officer. that is the main criteria. So, and in that CBI case which I mentioned, Sanjay Chandra, they said the objective of a bail is not punitive or preventative. It is just to secure the attendance of the accused on trial, and it also stressed on the principle of innocence until proven guilty. So, and Sanjay Chandra dealt with that 2G spectrum case, that which dealt with large scale financial crimes, corruption, bribery, damage to public exchequer by rigging contracts to obtain the spectrum technology. So the court, despite the serious charges and the investigation by the CBI, proceeded to grant bail to the accused, stating that the court was mindful of the seriousness of the offense, but this ground alone was not enough to muster when the investigation of the case is not complete and the charge sheet is not filed before the special court. The court actually related under trial incarceration for infracting the personal right to speedy trial, enshrined and guaranteed under 21. So there is also the power to release on bail under CRPC. When is the power there? When the procedure of investigation is not completed in 24 hours. Then when can, there are special cases where under PMLA or NDPS, you don't get bail easily until and unless the quantity specified of whatever has been recovered from you, the quantity of drug is less than the limit prescribed. That time they may grant. But if it is over and above, no, you don't get bail. So I will kind of reiterate the factors, to be borne in mind when you are applying for a bail, when you apply an application for a bail and a bail application to be considered. There has to be prima facie or a reasonable ground to believe that the accused had committed the offense. If the court feels, no, this is a serious crime, here the accused has committed the offense, then he may not grant bail. So when you make an application, you must say that, no, I was not involved here. I was not, this is a false allegation imputed and the false imputations against me. I have nowhere committed the offense. You give an alibi or whatever. And what is the nature and gravity of the accusation? In heinous murder, then terrorism, sedition, where it's going to cause a lot of public unrest and things like that, normally courts don't give. And what is the severity of the punishment? If it is about 10 years, then they are not liberal. It is within 7 years, yes, they may think of granting you bail. And what is the risk involved? Will the accused abscond from justice? Will he flee the country? There are so many people who have committed economic offenses who have fled the country. Although they were on bail, they have fled. Choksi, Neeraj Yadav, Vijay Mallya, Lalit Modi, all these people, they have just left. So, and then another thing which is to be taken into consideration is their character, behavior, whether they have the means to influence the witnesses, whether they have the means to tamper with the investigation, what is the standing of the accused in society. So it's a two-way sword. Sometimes they say, yes, he's very respectful man, respected man, they may grant bail, or they may say, they may use it against him saying, no, if उनको बाहर छोड़ दिया तो पता नहीं क्या हो जाएगा, witnesses का पता नहीं गायब हो सकते हैं, they can be mowed down, towed down, run over. So these are cases, it varies from case to case, and whether there is a likelihood of the offense being repeated. So, and the reasonable apprehension, whether witnesses can be influenced. So there are so many things when bail has to be considered. It is just, see, bail is not rocket science as such, but you have to apply your mind. And every case, it's not a yardstick. A same yardstick cannot be adopted. It differs from case to case, from file to file, from person to person. So in this Ram Govind Upadhyay's case, the court emphasized, and that was in 2002, that the order granting bail is a discretionary right, and the court pronouncing orders on this liberty, they have to spell down the cogent reasons for its conclusion. It cannot just say bail granted or bail denied. They have to put down their reasons as to why they are granting bail or why they are not granting bail. See, and there is another thing also, cancellation of bail and rejection of bail. Okay, so in what is rejection of bail? Bail, you apply for bail, it can be rejected. Simply say no. You come after 3 months, you come after 6 months and reapply. At this stage, we find that we see no reason as to why we need to grant bail. The offense is very serious. You need to, suffer another 6 months more. Then you come. Cancellation of bail. When does cancellation of bail happen? Cancellation is when a bail is granted and then it is cancelled. So it cannot be cancelled in a mechanical manner. There has to be compelling circumstances to circumvent the freedom granted by the court to that accused. If they are taking a step forward as to cancel the bail, there must be compelling reasons for it. Very compelling reasons. In the last week of December, a bench of Justice Nagaratna and Justice Mahadevan, they cancelled the bail of a man because when he was out, he was inside on a murder and he had got bail for 302. He was out. And when he was out, one of the witnesses was killed, died under suspicious circumstances, mysterious circumstances. So they had every reason, because all the fingers pointed out to the man who's on bail. So they had to cancel the bail and ensure that he goes back. See, normally, why do they cancel bail? They cancel bail because he misuses his liberty by indulging in similar criminal activity, interferes with the course of investigations, attempts to tamper with investigation or witnesses, threatens witnesses, or indulgence in similar activity which would hamper smooth investigation. Even a threat is sufficient for a man to backtrack or resile from his statement, or he may not appear, he may not give evidence. The fear is there. It is hanging large on their heads, so they wouldn't want to. And there is likelihood of him fleeing to another country. And sometimes after granting bail, he doesn't cooperate, he doesn't come and give his attendance, he does not, he goes underground and he doesn't become available to the investigating agencies. So he is not within the survey of the police or something, goes underground. So in these kind of circumstances, the court can always cancel bail. So cancellation is completely different from rejection of bail. So, and there is another case, where Supreme Court, not in Supreme Court, the Bombay High Court in 1958, they cancelled the bail. The power to cancel the bail, I'll just read it out for you. Made a note of it. So, yeah. Yeah, the power to cancel bail was exercised by the Bombay High Court in Madhukar Purushottam Mondkar, 1958, where the accused was charged with a bailable offence. The test adopted by the court was whether the material placed before the court was such as to lead to the conclusion that there is a strong prima facie case that if the accused were to be allowed to be at large, he would tamper with the prosecution witnesses and impede in the course of justice. So that was the test, and it was laid down in 1958. That it was then they decided they had exercised the power to cancel bail. Then there is another appeal which is preferred by the accused against the judgment of the Bombay High Court, and that was then appealed there. So, and in Gurcharan Singh versus State of Delhi, while confirming the order of the High Court cancelling the bail of the accused, this I'm referring to a 1978 case. and it's reported in 1978, 1 SCC 118. The court observed that the only question which the court had to consider at the stage was whether there was a prima facie case made out on the statements of the material witnesses and on materials that there was a likelihood of the appellants tampering with the prosecution. So it is this application of this test and this test alone, influencing witnesses, tampering with the investigation, and threatening and flight risk. It is only on these four conditions that bail is cancelled. So here, when I was telling you about this Justice Nagaratna's judgment, they cancelled the bail on a petition filed by the complainant in the case because a witness was found dead. So the latest is where Supreme Court cancelled the bail. So there are a lot of examples of high-profile cases, like where involving politicians, like you have Arvind Kejriwal, Manish Sisodia, that K. Kavita. Then you have, these, there are many cases like famous cases of big politicians. So they have been brought to the forefront only, why? Because of their allegations of misuse of power and judicial discretion. Arvind Kejriwal, he was actually granted bail. He was arrested for defamation, but later on he was granted bail. Then you have the Delhi policy, Delhi's excise policy, where Satyendra Jain was kept in custody for 2 years. They refused to give him bail. Why? Because he was the health minister. He was very powerful. He had the wherewithal to tamper with the investigation, to influence witnesses. So they did not give him bail, and then ultimately they found that there was no case against him. So then the case went, but they had to do it because they are all leaders. People look up to them, and they cannot misuse power. Another concept of our jurisdiction, of our jurisprudence, is that all are equal and nobody is above the law. All are equal before the law, and none is above the law. So that principle has to be exercised. So then you had this K. Kavita. She was also a BRS MP from Telangana, and her team had sought anticipatory bail, which allows to avoid arrest. So in pre-arrest stage, where she has that fear of getting arrested, she applied for anticipatory bail. So, and these are cases where political motivations are suspected. When she has apprehension that my opponent is going to, implicate me in this, I will go and get bail. Then you have this another case of the Deputy Chief Minister of Karnataka, D.K. Shivkumar, who was arrested in 2019 on charges of money laundering. He was denied bail multiple times, but he spent 50 days in custody, and then court granted him bail. And the court also emphasized on the fact that the pre-trial detention should not be punitive, and so they granted. Then you have this poet and activist Varavara Rao, who was arrested in the Bhima Koregaon case, violence under the UAPA, that is the Unlawful Activities Prevention Act. He spent 2 years in jail before granted bail on medical grounds by the Bombay High Court. Then you have that Father Stan, who died in jail when he was he was not granted bail. So they have to actually balance the need to protect the individual liberty with humanitarian considerations. In this, even after keeping Varavara Rao for 2 years, they ultimately granted him bail because of his medical condition and his age, advanced age. Then you have this widely discussed case of this guy called Prabir Puryakasta, who is the founder of NewsClick. He is an independent media platform. He also was arrested in October 2023, and he was accused of receiving foreign funding to spread alleged pro-China narratives. So his bail plea was denied many times because of the UAPA, because that is a very strict act itself altogether. So, but that was, he was arrested. Why? Because they wanted to suppress media freedom and dissent. They say dissent is the hallmark of a vibrant democracy. But in today's times, dissent is seen, is not taken very nicely, taken very kindly. Anybody dissenting, they try to gag their mouth, their freedom of speech. Then you have the Sanjay Raut, Shiv Sena MP, who was granted bail after multiple rejections in his money laundering case. See, the court acknowledges the fact that, prolonged detention without a trial, it goes against the very personal fundamental liberty guaranteed under the constitution. It once again reflects, when in these kind of cases, whether it's personal liberty, which should be given important, or the importance of upholding the principle of bail, that should be considered. And then you have the case of Aryan Khan, just as Mr. Shah Rukh Khan's son, the famous Shah Rukh, his son, it drew massive media attention. Why? Because he was arrested by the Narcotics Control Bureau in 2021. There was no concrete evidence linking him to drug possession or consumption. And his bail was denied multiple times. Why? He had to pay the price because he was Mr. Shah Rukh Khan's son. So there was so much of media attention, it was so sad. That boy did not have anything. He did not have anything on him, but still they never gave him bail. Because sometimes the judges are influenced by what the media is going to write about them. What are they going to be portrayed as? So ultimately, it was the Bombay High Court that granted him bail. And it underscoring, the importance of applying the rule fairly and not depriving an individual without sufficient cause. Then you have this case of Riya Chakravarti's in a drug-related case following Sushant Singh's death. That also became a media spectacle. She was also hounded and haunted, and media wrote everything about her, and there was no evidence at all. So after several bail rejections, the Bombay High Court finally granted her bail, stating that there was insufficient evidence to justify her continued detention. So sometimes we don't know whether fame is for good or for the bad, especially in cases like where you're falsely implicated, when there is no evidence to support the prosecution case, or there's no evidence to detain you, but still you have to bear the brunt of fame. So sometimes what does this lead to? You say bail is the rule and jail is the exception, but here I put it the other way. I put it like this: jail is the rule and bail is the exception, because it has come to this stage now. At this point, when I'm speaking right now, the scenario has changed. The political scenario has changed. Comedians are taken into custody because they say something. People cannot accept or handle criticism. So they are taken, and poor Rahul Gandhi has been, implicated in so many defamation cases because he says RSS is this, or Savarkar is this, or something. Despite having been acquitted of the charges in many other cases, still multiple cases are always filed against somebody who speaks against the mindset of a political mindset or a political theology they don't follow. So now, if you see of late this incarceration of Umar Khalid, it serves as a stark reminder, of how special statutes like UAPA can flip this principle. He has been detained for 4.5 years. Ultimately, Justice Arnesh Kumar has given him bail. Why? Because he was suspected of, Delhi riots conspiracy case. He was targeted for being the main conspirator. And even without a trial commencing, he had spent 4.5 years in prison. So this is it. Then, we have this Devangana Kalita, state of NCT versus Delhi, Devangana Kalita, where the Delhi High Court granted bail to 3 student activists arrested for inciting Northeast Delhi violence. Under the UAP, again, the High Court observed, their bench, it said it cannot discuss merits in the bail proceedings as per Watali's judgment, and it cannot discuss the inferences drawn by the NIA based on evidence in the charge sheet. So the bench separated the actual evidence from the inferences, and this was a very rare instance where bail was granted on the basis that the National Investigation Agency had failed to make out a prima facie case against the accused. So the general trend, as indicated, is to grant bail on account of delays in trial. Hence, if they require the accused, even if you want to grant bail, the court, we have to impress upon the court, look, my lords, without a trial, without a examination of witnesses, without a charge sheet, he has spent 3 years in jail, he spent 4 years in jail. So this is something very pathetic. That should not be the ground. So, and when you take the NDPS Act, the philosophy of bail takes another drastic turn. So it pertains to the consumption of commercial quality, or how much is in his possession. So these are things about right. Then you have this another very landmark judgment of Satyendra Kumar Antil, in 2022 10 SEC, where it laid down guidelines to be followed in conditions. There are 4 categories which Satyendra Antil gave, Justice Kishan Kaul and Justice M.M. Sundresh. They said the person should not be arrested during the investigation. Then they said a person who should have cooperated throughout the investigation for offenses less than 7 years, and he should be permitted through a lawyer. So there are so many 4 conditions they put under PMLA, under economic offenses that are not covered under any act, whether the word trial when it has not been defined in CRPC. Therefore, they gave an extended meaning to the word for the purpose of enlargement on bail. So the primary stage of investigation, police custody after arrest, may be warranted for a thorough investigation. So that's they ensure that Arnesh Kumar should be followed, and bail refers to provision of secure surety, which is inclusive of personal bond from the accused. See, when I say personal bond and surety, I have appeared for many cases in the legal sector. So the legal services authority of Supreme Court, I have appeared for many. So there have been criminals who've been sitting inside for many years, and their appeal is admitted, and they are not granted bail. And even if they are granted bail, what happens is they are not able to give surety. Why? They have been separated from society. They don't have family. They are treated like criminals. And so there is nobody to come and give security or surety. So then I had to bring it to the notice of the court. I think you please relax the bail conditions. Then they asked me why. I said, please look at the man inside. He has been incarcerated for so many years. He doesn't have family. He's an illiterate. He's suffering from poverty. There is nobody there. So who is going to come forward and give him surety? So you will have to relax the conditions. So that matter is now pending before a 3-judge bench. Whenever it comes up, it will come up. So these are practical things that have to be looked into while granting bail. How will a man, an illiterate man who's been cut off from society, serving imprisonment for 20 years, get a surety or get a bail? No, it's not. And if he doesn't have family, so what? So you impose some condition, like you come to the nearest police station and sign every 15 days and go. So that is how it is. So this was my bail webinar. Shreya?
Yes, ma'am. Ma'am, there are a few questions in the chat box. I will read it for you.
Yeah.
So, Advocate Rishu Pandey asks that when a judge interrupts during the bail hearing, saying that counsel, you're arguing on merits and not on bail, what all specific reframing techniques can advocates use to effectively continue their arguments within proper boundaries?
See, I'll tell you, it's a simple thing. I've already explained it to you. Here, you don't have to raise your voice. You just have to spell out what is the gravity of the offense, what is the seriousness of the crime, what is the sentence involved, and you give the parameters as to what his education is, what his background is. He's been falsely implicated. You don't have to go to merits. These are the three things: no flight risk, no tampering of witnesses, and no tampering of evidence, and no influencing of witnesses. Basic, this is the thing. And also specify, see, as I mentioned earlier, every case is different from the other. There is no yardstick or a straitjacket formula. So you have to, and see, by raising your voice and shouting, nothing is going to happen. No, you improve your argument. You just tell the court, this is it, and this is how criminal jurisprudence is. This is how it is. See, and another thing in today's world, let me give the practical aspect. Most of the trial court judges do not give bail. You know why? Because the fear looms large over their head, saying that if I give bail, I will be known as a corrupt judge. People, whether he's corrupt or not, immaterial, but they will say, oh, he sold his conscience, he must have taken money. So it is very traumatic. It is about integrity. He feels that even if he spells out his bail order with all reasons covered by entire Supreme Court cases, right from 58 to 78 to 2008, the fear looms large. So most of them do not give bail. They say it is better to reject bail than to have my name tarnished. And he would not have taken money. But still, the judiciary nowadays is looked down upon. Unfortunately, people don't look up to the judiciary with that much respect. Why? Because there is every person giving gyan on social media, on every reel, on every Twitter, or everywhere, something. They have to come up with their own two-bit. So that should be stopped. That should be stopped.
Indeed, ma'am. Ma'am, Mr. Rajiv asks that what are the main aspects and grounds that are considered by the court if the court taken up any simple bail and if taken up under special statutes like NDPS? And then he also poses a follow-up question in regards to same that if any co-accused have been granted bail on identical facts, can parity be ignored without recording special reason?
See, parity can be ignored. It cannot be ignored. See, it depends. It is always invoked when accused seeks bail because their co-accused has already been released. Parity principle ensures that the co-accused in similar situations are treated alike. But that is not absolute. Why? Because if two people are accused of the exact same rule, and it is discriminatory to grant bail to one and deny to the other, but it also ensures consistency and fairness. So what they have to see, what is the role of the person, what is his conduct, is he a first time offender, is he a second time offender, did he instigate, did he provide the weapon, or was he merely standing and watching the crime happen, was he just a mob looker. So his criminal antecedents, whether he had surrendered voluntarily or he evaded arrest. So these are things. It's just because that man was granted bail, it's not your birthright to be granted bail. So these are factors which the court looks into, whether he surrendered himself or he evaded arrest. That itself shows that his mindset. If he had surrendered on his own, that would have shown that he was not involved. If he had evaded arrest, what does that mean? That he had that notion, he had that mindset, he must have been implicated, he must be involved in the crime. So, it is not just because he's been criminal. No, it doesn't happen like that. Whether he will tamper with the evidence, whether he will influence the witnesses, is he a threat to society. So these are all parameters that need to be taken when you consider parity. Have I made myself clear, Shreya?
Right, ma'am. I
So,
totally, yes,
mhm.
ma'am. Ma'am, Miss Sarita Kumari asked that could you please throw light on the aspect of post-conviction bail?
I gave you an example of Sengar, that is post conviction only. So it has to be looked into in its own, in the particulars of its own case. You cannot have a simple yardstick for everything. No. Post conviction bail, he has been convicted. He's not an accused. The trial has completed. He is convicted. So normally they will ensure that more than half, if his sentence is 14 years, he should have at least spent 8 or 9 years. That's when it's considered, not before that. They don't. Normally, they don't.
Indeed, ma'am. Participants are requested to pose any other questions in the chat box if you want to ask ma'am. Ma'am, by the time the participants are asking the question, may we take the opportunity to introduce our course to them?
Yeah.
Thank you so much, ma'am. So the participants, we are delighted to introduce our course. So at Law Learning Bench, our mission is to bridge the gap between legal education and courtroom practice. We don't just teach law, but what we do is to shape the confident, ethical, and courtroom-ready advocates who are prepared not to just uphold the justice, but to have fair dealings in the real world. Now the course will help you to understand that how practical advocacy skills enhances your legal education and how the program organized by Law Learning Bank, the CAS-TP, supports you in building strong real-world courtroom competence alongside the academics. Now we already know that what we know is to have a strong theoretical base, that is the legal concepts, statutes, and case law. But that foundation is indeed powerful. But now our goal is to convert that knowledge into real courtroom strength. Now let me ask everyone honestly that if you had to stand before a judge today, how confident would you feel? This question is exactly why programs like CASTP exist. In class, we learn definitions and distinctions, but in court, it's about proving intention, establishing facts, handling contradiction, and convincing the judge. That is where the skill meets the knowledge. The real courtroom matters are rarely straightforward. Facts can be incomplete, evidence may be missing, and strategies change dynamically. This requires sharp thinking, adaptability, and strategic decision making. Young advocate often faces the challenge of procedural confusion. There is drafting pressure, credibility issues, confidence challenges, and ethical dilemmas. These challenges delay the justice and affect the trust of client. True courtroom advocacy demands more than knowledge. It requires identifying the right provisions, organizing evidences, understanding the precedents, handling witness, making structured arguments, and presenting confidently before the court. To succeed in court, students must master preparation, application, adaptation. There must know filing of procedures and handling post-listing scenarios. These are the finer details that shape the real-world lawyers. Law school builds your foundation, but what we aim is to strengthen your courtroom readiness. Law Learning Bench works alongside your institution to build well-rounded legal professionals prepared for practice. Through CASTP, you'll learn how to convert theory into courtroom strategy, draft like practicing lawyers, engage in realistic stimulation, and work with real legal documents and drafts. This training gives real world clarity, helps you understanding how the court functions, how it reinforces your theoretical learning, and offers collaborative learning between academia and practice. In short, CAS-TP bridges the gap between textbook learning and courtroom performance, preparing you for a successful legal career. CAS-TP is a structured training program which is aligned with your curriculum taught by experienced professionals from both academia as well as from the professional practicing at the bar. It offers live expert lectures, limited seats for personalized attention, structured material, weekend classes, and one on one mentoring, a complete professional training ecosystem. Student exercise, live courtroom observation, interactive workshops, expert led sessions, and continuous personalized feedback, bringing real practice into learning. We are guided by some of the finest legal minds, former judges, and senior legal luminaries, ensuring every learner receives the highest quality of mentorship. The modules are structured to take you through the entire advocacy journey, from introduction to advocacy to client interaction, courtroom behavior, drafting, oral argument, witness handling, evidence bail, ADR, technology, ethics, and finally mock trials with performance review. By the end of this course, you just don't receive a certificate, but you walk out as a transformed, confident, and courtroom ready advocate. If you aspire to become a strong legal professional, CASCP will help you become one too. Thank you. And now we move forward to the Q&A session. Ma'am,
Yes.
ma'am, there are a few more questions in the chat box.
Yeah.
So Mr. Rahul Pandey asks that if the accused is foreigner, then the same principle of bail will be applied or any other consideration will be taken by the court.
No, the principle of bail will be applied to a foreigner also. He will be also take the same yardstick will be applied, because ultimately he's a criminal in the eyes of law and the crime committed on Indian soil. So if you see that famous case of that Augusta Westland chop-off scam, Christian Michael James, he was also in custody for 7 years. For 7 long years, they didn't grant him bail. Then ultimately they had to grant. So that's the same parameters.
And ma'am, Mr. Ajneeb asks that if that ma'am Arvind Kejriwal and Manish Sisodia got bail because of too many witnesses to be examined, is it a valid ground?
It is a valid ground that if there are 76 witnesses, you're not going to, because there again, your liberty, your right to liberty, you're being punished without even, being the trial being completed. And if at the end of it, like Satyendra Jain, after 2 years of incarceration, the case found that there was no evidence against him and they had to quash their fire. So who compensates him? Because in India, there is no compensation principle here. If you are falsely implicated and then you spend the rest of your time there in court, who gives you any compensation? Nobody gives. So, I mean, at the end of it, is it a fair deal? And like in Delhi High Court, there was this latest case of Delhi High Court where the accused has been acquitted after 16 years, 16 long years, and the acid attack survivor says that justice is not done. See, 16 years he's gone, he's paid the price, whether he's repented or not repented, but an eye for an eye makes the whole world blind. So that should not be the principle. So what according to her is justice? Put the acid on his eyes, make him suffer the same pain? Then what is the difference between a human being and an animal? So there are so many things that you need to see from that point of view, and from the philosophical point of view, from the practical point of view. So, and then when it comes to justice, justice is a kind of an evading thing. What is justice to me may not be justice to somebody else. And here, before a court of law, just remember, nobody can be happy, because it's a litigant and the state, or there are always two persons. So can the court make the persons happy? No, one has to be happy, one has to be satisfied with the verdict. Ultimately, justice was done or not, that again is another question which evokes a debate.
Yes, ma'am. Ma'am, we do not have any further questions.
Thank
Uh,
you.
Give us a format where we conclude the session.
Yes, thank you so much. Thank you all for logging into the webinar. I hope you found this session useful or good. Thank you so much. And I hope you all have something to take away. And I wish all of you a very, very happy and a prosperous new year 2026. God bless you all. Thank you.
Same to
Thank
you, ma'am. It was a wonderful lecture delivered by you. It was very, very thought-provoking and very enlightening. Best compliments to you and also very, very happy New Year to you.
Thank you. Thank you. Thank you, Shreya. I leave. Thank you.
Thank you so much, ma'am. We would request all the participants to kindly stay back. We will be circulating a Google form via the chat box and request you to kindly fill the same in order. The form will act as a feedback for us so that we can aim to improve further. The feedback form link will also be shared on your personal email ID. So we request you to kindly record your responses there. Thank you everyone for joining in.